has filed LPA number such and such 37/15, which was dismissed on 25/10/2018. Therefore, the matter was sub judice before the Superior Court still the year 2018. The workman has filed Exhibit 5, which goes to show that on 17/8/2019 he has sent again a petition to the management and filed present case on 15/9/2021. No doubt there may some delay in filing case on the part of the workman, but under the circumstances of the present case, when management was directed to send order of reinstatement through speed post and must reinstate the workman within 2 months, and the management, instead of reinstating the workman, has challenged the award before the Honorable High Court and LPA. The management was dismissed by the Honorable Court in 2018. It cannot be said that the present claim is stale claim. Mere on reason that the workman has not filed application before this on the court, no order under section 17B of the ID Act has been passed. It cannot be held that the applicant was gainfully employed, etc. So it has been dealt with. Now one thing more. Your Lordship may kindly see, your Lordship has not seen, my learned friend also not seen, in absence of any interim order, they will not comply. In one hand, they say this is hit by this argument is hit by approbate and reprobate. Once they are challenging the award, and the award is pending before this one court years together. Now he says that I have not approached. I have approached. He says that I am ready to pay the amount, but he did not approach me. It is very easy to say so, but it is approbate and reprobate, blowing hot and cold at a time. This is one part. Then your Lordship may kindly see how the learned labor court has dealt issue number 3, that is not even whether I was gainfully employed or not. Now discussion, after discussion, para 31 and 34. Para 31 and 34. Para 31, your Lordship may kindly see me. So far the question of gainful employment of the workman is concerned, I find that the applicant workman during his evidence has denied his employment anywhere and stated that he was dependent on the earning of his wife. The management office suggested AW1 that he was doing some work in last 10 years, has returned home such and such. Thus the management has tried to set up a case that the workman was working at another place outside Ranchi, but the above case of the management is itself falsified from the statement of OPW3, who has stated that the applicant is residing in Tatisule, Ranchi with his family. The management has not suggested that the workman about the place where he was working. The OPW3, then not 34.
Yes,
So,
I see.
yes.
That should be
So
sufficient.
this is a fact-finding judgment based upon the evidence available on record. Discuss, well played, discuss. His claim was 14 lakhs, but it was reduced to 3 lakhs.
That's right.
So there is no scope. Not of course, more than 30 lakhs might have been the expenditure of the management. Now they feeling shy to pay 3 lakhs. Of course, my learned friend has given a good gesture by offering rupees 1,50,000. This is my summary.
The learned counsel for the concerned workman has submitted that the award is a well-reasoned award the impute order is a well-reasoned order in every aspect of the matter. He submits that the evidence of OP number 3, the private detective, has been duly considered and every aspect of his evidence has been taken care of. The learned counsel has further submitted, has referred to paragraph number 16 and also paragraph number 32, and has submitted that as many as 7 reasons has been cited by the learned court to hold that the evidence of OP number 3 was not trustworthy and inadmissible in evidence. The learned counsel has also submitted that OP number 3 had stated accepted in evidence as the same was not accompanied with any certification under section 65B. ये आपका submission है, Mr. Sani?
Yes.
It was
Yes.
required. It was not accompanied with any certification under section 65B of the Evidence Act. He submits that the certification is not a matter of procedure, rather it gives the authenticity of the recording in the pen drive. The Learned Counsel has then submitted that the delay in filing the case before the Learned Labour Court under section 33C2 has also been explained, and for that purpose he has referred to paragraph number 31 and 34. 34 of the impute order. He submits that the workman had sent Exhibit 2 on 27/4/2013 and prayed for his reinstatement, but the petitioner had challenged the award before this court and throughout litigated the matter. The Learned Counsel has further submitted that at paragraph number 38, it has been recorded that there was no evidence on record to show that the management had issued letter to the concerned workman for his reinstatement and payment of rupees 7,000, and admittedly rupees 7,000 was offered in the year 2022 before the court proceedings. The Learned Counsel has submitted that the judgments which have been cited by the petitioner have been duly considered by the Learned Court, and there is no perversity. The Learned Counsel has also submitted that although much higher amount was demanded by the concerned workman, but the Learned Court has duly considered the materials and came to a finding with respect to the admissible amount to the concerned workman and computed the same, and only a meager amount of rupees 3,06,277 has been ultimately directed to be paid to the concerned workman. The Learned Counsel submits that the management cannot blow hot and cold at the same time. Once the management files a writ petition and does not wish to implement the award, it was for them to seek an interim relief of stay from the court, but admittedly no such order of stay was passed by the court, and therefore the management was under legal obligation to implement the award. That's all.
Yes.
Concluded.
It is two-tier litigation, but in this proceeding is two-tier.
That's
Once they have fought, not they have lost up to LPA, then CMT.
I will,
Now this
more
is second.
I will give the reasons. I have recorded your submissions.
But there is
This-
one document that I have annexed that even after the order, I have given him a letter of reinstatement, copy to the
That
Labour
has got no
Department,
relevance. We know
not
this.
coming till now, no statement in their counter
He
affidavit.
has
also.
attained the age of superannuation.
No, no, he will not. He was only 20 years. काम ही नहीं करना है.
नहीं ऐसा बात नहीं, काम नहीं करना तो
आज भी नहीं आए.
अगर हम 33
And I have annexed that document and now I'm giving a copy to the Labour Department.
गया क्यों? अगर काम ही नहीं करना था
क्योंकि 12 साल में पैसा बना लिया बिना काम किए.
तो
अभी
बोलना
चले
बहुत
जाए आपके
आसान है.
पास. अभी चले जाए, आप रख लेंगे.
हाँ
चलेंगे.
आप रखिए.
अभी चलेंगे, आप
आप
रख लेंगे अभी.
नहीं कर लीजिए क्या?
हाँ ठीक है, हम दे देंगे. I have given a letter. It is an extra. I am not backing out.
Now मेरा there are two.
Let him come and join too.
सेकेंड राउंड 33C2 होने के पहले आप उसको
हाँ,
ज्वाइन
ये नहीं बोले.
2023 से लेबर डिपार्टमेंट को कॉपी
2011 से लेके 2026 हो गया, अभी 15 साल से पूछ नेल लड़ रहा है. आप कहते हैं कि हम भी रेडी हैं उसको देने के लिए अपॉइंटमेंट.
In response, the
इतना तो
Learned
कम
Counsel
से-
for the
नहीं, अगर ऐसी
petitioner,
बात
just a
है-
moment, in response, the Learned Counsel for the petitioner has submitted that a letter was issued to the
Page
petitioner to
107.
join
107 नंबर.
at page 107 to join the petitioner company, but the
Copy to Labour Commissioner.
with copy to Labour Commissioner, but the petitioner never came and joined.
वर्किंग्स.
But but the
Respond.
workman never gave his joining. However, this letter is not a part of the record of the Learned Labour Court.
It is not the part of labor code.
It
This
is
has
not
been
a-
filed with the writ petition.
Right, it has been simply filed with the writ petition. The counsel for the concerned workman has submitted that he has no instruction so far as this letter is concerned. That's it.
Yes.
dismissed. इसको रिजर्व करने का जरूरत नहीं.
उनके ऊपर क्यों आए? जो कर
हाँ?
जो करने का जो
नहीं, withdraw it, but I have dismissed it.
हाँ।
बाकी हम लिखा ही नहीं है यहाँ. I will just give maybe 3-4 paragraphs reasons and that's all. 65 भी तो हमको डिसाइड करना
और
है.
इतना गुड जेस्चर था जो 7,000 रुपया कॉस्ट था वो भी नहीं थी.
In
Sir,
fact,
यही
there
तो
is
मैनेजमेंट
a
हाथी का
judgment
मतलब
of
2 दांत होता है, एक दिखाने का एक खाने
there
का.
is a judgment of Justice Krishna here on the question of labor laws, in which he made that famous line that procedure is the handmaid of justice, and procedure cannot defeat, and therefore, and he says it is rough and ready justice in labor laws, and we are making it hyper technical.
That's it.
But nobody is following that judgment now. It is a 70s judgment.
70s judgment, old judgments do not.
Although this benefit management never wants to point out because labor को बहुत फायदा होता है उस judgment से. Covers all their loopholes.
That's it. Carry on. Okay.
First finding, item 2, DA 6096 of 2026.
Yes, petitioner.
Yesterday is not appear with the doctor taking possible.
Sir, supplementary का काम क्या है? ये बेटे supplementary कौन सा है?
इसको पास ओवर कर दो. Just pass over. We do not know भाई कौन है इनका advocate.
कल भी वे एक बार possible लिए कल दिन भर बैठा रहा सामने.
कल पास ओवर लिए थे.
हाँ first हम.
Then he is.
Supplementary का काम. इसमें senior will argue in this case.
कहाँ किसी ने?
I'm correct. कल भी आपने टाइम लिया. इसमें after week वो नहीं आए. कल भी नहीं आ पाए. Monday या Tuesday को रख दिया जाए.
Victim से support करिए क्या करना है?
इसको एक बार करेंगे जो एक बार लेडी से रख दिया जाएगा Tuesday को.
Tribune order कब का है? 27 को. Learned counsel for the petitioner seeks adjournment by submitting that his senior would argue the case. Yesterday also the case was, nobody had appeared in this case.
मतलब petitioner.
Paragraph paragraph 21 of the petition reveals that out of 6 charge sheeted witnesses, 3 have already been examined. Since an adjournment request has been made, pose this case on 31st of July. Let the present status of the case be called for from the concerned. दो चार और डेट पड़े तो सब एग्जामिन करो. Victim has supported. क्या है? हम यही ऑर्डर करेंगे आप.
इसमें कॉन्ट्राडिक्शन है किसी.
तो हम यहाँ पे ट्रायल कर रहे हैं.
ये ट्रायल बट हम लोग यहाँ पे
इसको ले रहे हैं.
आपका ट्रायल कंप्लीट करा. बता दीजिएगा कैसे ये.
31st को रखते
बहुत आप टाइम मांग रहे हैं ना. बस जब आप टाइम मांगेंगे तो टाइम को आपने अनुसार.
From the daily list and rating for orders, item 10, WPC 4951 of 2018.
Yes, sir.
Respondent number 8A to C. Notice was not served upon them.
That has been solved. Yes, A to C. Yes, sir.
भी इसमें ऑफिस नोट में है कि थ्रू मदर ही और सी
Mother for service is not sufficient. Yes, you tell me. मैं तो पेपर पब्लिकेशन करा देते हैं पूरा ऑल ओवर इंडिया का सारा न्यूज़.
नहीं लो इसमें ए को सेंड पर्सनली आया है रिलेशनशिप और इसके बाद 8 बी और सी का है थ्रू मदर.
Not sufficient.
It is sufficient.
As per the office note, notice upon respondent number 8, proposed respondent number 8 with bracket A has been served personally. So far as respondent number 8B and 8C are concerned, the same has been served through mother. The learned counsel for the petitioner has submitted that. Appeal unto us. petitioner
Petitioner.
has submitted that the notice may be accepted as valid upon respondent number 8A to 8C. You are for?
I'm for respondent number 6.
The learned counsel for the respondent number 6 has no objection. Considering the submissions and the office note, the notice upon respondent number 8A to 8C is accepted as valid. What else? The substitution,
Substitution.
are you member? Substitution has not been allowed. Has been allowed, not allowed. Notice was issued after
Copy has
substitution.
not been served upon the verification. Are you for substitution?
Respondent number 8.
You are not aware. After substitution.
5. We have 5 orders.
That is
IA
allowed.
number-
When was it allowed? Or it is yet to be allowed?
E- It is yet to be allowed.
That is IA number?
A to C?
No, let's see, it has been. And notices were sent in this
Eight
only.
Has been allowed after.
Yes, IA notices were
A
sent.
to C, they must be the substituted legal heirs of respondent number 8.
Prayer was allowed.
Yes.
Proposed legal dilemma. Respondent number 8 was a contesting party. Yes, ma'am.
I am the main contestant.
Now, otherwise the case is complete.
Yes.
It is an admitted matter.
And actually, let's say it is a assigned matter because petitioner happens.
Assigned तो हमको दिख रहा है, रीड का मेरा बोर्ड नहीं है ना.
Yes, right.
So, I just want to know, is it an admitted matter?
Earlier it was admitted.
When? No. When you say it was admitted? When you want to do it, or you don't want to do it?
No, let's any next week any day.
Counter needs to be
You want to file counter?
the highest.
You are filed? Not filed.
No, con-
After this completion of notice for the first time, it is being heard.
You are for respondent number 6.
6. And the state is also a necessary party to file the counter.
You are filed counter?
However, state has filed
The
it.
copy will be.
2 to 5 has filed it. 6 has to file it. Okay. What about 7? Who is for 7?
I'm not.
Has notice been issued to respondent number 7 ever? Yes. Yes. Notice
Let
was
it- White order dated, let me see, 37/2025.
Hmm.
Fresh issue order was to file a fresh issue notice to respondent number A to C, which
we are not bothered about 8 to 8. I'm asking you where the other respondents are.
but office note reveals only about respondent number 8 only.
How long have you been practicing?
Actually, additionally,
How long have you been practicing?
4 years.
4 years. You need some training from Unchi
Yes.
because you do not know. Firstly, you do not see the records, and apparently you do not know how to see the records.
Apologize.
Munshi is the first teacher of an advocate. Are you aware?
Yes, sir, of course.
Have you ever filled any form of notice? Notice
Notice.
कैसे भरते हैं पता है? नहीं पता है ना?
I have seen.
वो भी सीखने की जरूरत है. दिख रहा है नोटिस हुआ है, नोटिस सर्व्ड है, कुछ पता ही नहीं है. सुबह से बैठे हैं फाइल लेके देखने तक भी कोई जरूरत नहीं है. आप लोग फाइल ही देते हैं क्या देखने के लिए? मांगते नहीं है. And wasting the court's time on this. The learned counsel for the respondent number 6 waits for 4 weeks time to file a counter affidavit in this case. When do you want?
Next week, any day.
4 weeks इनको टाइम चाहिए आपको नेक्स्ट वीक चाहिए.
Then after the
Counter affidavit on behalf of respondent number 1 to 5 has already been filed. Rejoinder to the counter affidavit, if any, be filed by 7th of August, post on 14th. क्या matter है? What is the matter, ma'am?
4H का
4H का proceeding है.
proceeding initiate हुआ against that.
Against the proceeding, initiation
No,
of
it has revision वगैरह.
Final order.
Yes, fine.
Item 11, first appeal 49 of 24, along with item 12 to 15.
On IAS for substitution, notices the issue.
Notice is the issue. You have appeared?
It was served through the local police station, except for one case, which is serial number 40.
First, let us take case wise.
In the first case, that is FA 49 of 24, notices were issued on responding to 1, 31 and 41, 21 and 41 personally served, and 31 to wife.
FA number 49 of 2024. The learned counsel for the appellant submits that the notice upon responding number 2 within bracket 1, 3 within bracket 1, 4 within bracket 1 has been served either personally or through their close relative. He submits that the notice be accepted as valid. Any objection? Are you there for the state? Any objection to this? Considering the submissions, the notice upon respondent number 2, 1, 3, 1 and 4, 1 is accepted as valid. What else?
Then there is this
IE was for substitution of?
first substitution for 2, 3 and 4. That has to be allowed, and then there is IE for limitation. That has to be.
The notice was issued on limitation.
Yes.
This is for IE number, this will be IE number 14893.
Substitution.
1. IE number 14893 of 2025 and first appeal number 49 of 2024. The learned counsel of the appellant has submitted that the respondent number 1, 2, 3 and 4 have expired. Respondent number 2 is the legal heir of respondent number 1 and therefore the name of respondent number 1 is required to be deleted. And so far as the legal heirs of respondent number 2, 3 and 4 are concerned, the details have been mentioned in paragraph 4 of the intellectuality application. Any delay in filing that? Abatement तो है, setting aside order.
I'm afraid if any, because I came to the knowledge of the death after the service report will proceed.
The learned counsel for the appellant has submitted that the appellant came to know about the death of respondent number 1, 2, 3 and 4 only on 37/2025 when the service report was received in the instance. He submits that delay in filing the substitution petition be condoned, abatement if any be set aside and the substitution be allowed. आप respondent है इसमें?
You direct to file notice.
Sorry?
We are filing.
You are?
Service of
हाँ,
notice.
that's
We are filing.
after, so far as the substitution is concerned, the learned counsel for the state has made an objection. Considering the submissions and being satisfied with the course shown, the delay in filing the substitution petition is condoned. The abatement is set aside and the substitution petition is allowed. The counsel for the appellant is directed to delete the name of respondent number 2 from the cost type, and so far as the other respondent number 2, 3, 4 are concerned, the necessary correction be also carried out. Necessary insertions be carried out in the cost title in writing during the course of the
I have to delete respondent number 1.
Okay. Respondent number 1 is to be deleted. That's right. Anything else?
Then there is limitation which has to be done.
Limitation was issued, notice was issued on limitation also. How much is the delay?
501 days. But that has been condoned in other batch matters. This is part of the existing batch.
Can we conclude the delay without issuing notice on limitation?
The other respondents have appeared in
Which is IE number?
3073 of 25.
3073. Who are the respondents who are appearing? आप इनकी तरफ से respondent number?
Respondent number 8, Deputy Commissioner Angad.
8. You see, limitation notice has to go up. Correct? IE number, please repeat your IE number.
3073 of 25.
3073 of 25. Issue notice in IE number 3075 of 25 through the concerned police station. आपको थोड़ा सा काम करना पड़ेगा. Upon respondent
1 to 7.
1 to 7.
Earlier notices were issued on all the respondents. Now the new respondents over which substitution has been allowed are only 2, 1, 3.
Earlier notice was issued on all the respondents. Which is that order?
11 to 25 are in FA 47, which is the next case.
11 to 25.
That was the main case.
Just. There is nothing for it.
FA 47, next case.
In the limitation matter also it was issued.
Yes, on the point of limitation.
Only on the point of limitation. I don't get it here. 11 to, इससे photocopy तो होना चाहिए ना? 11 to 25. There is no such order. 11 to 25. FA 48 का ऑर्डर दिखाई है. इसमें क्यों नहीं लगाते हैं साथ में? फोटोकॉपी नहीं है. This is not there. 16:1, then I have 11 to 25. Yes, 48 का ऑर्डर कहाँ है? 11 to 25.
ठीक है सर, इसमें 47, 50, 53, 54.
ऑर्डर की कमी. 11 to 25 का ऑर्डर FA 48.
Yes,
47.
47.
नहीं, FA wide order passed in FA 48 of 24. Just give me that.
Yes.
Adjudicatory order है, why the same orders are not placed in all the records? Should be placed as per the norms.
Yes, sir.
मेरा order है ना, तो हम उसका class बनाएंगे जो भी stenographer. Why is it not there? Batch case में तो सब record में order होना चाहिए. I am not able to get it. Who is for the private respondent? Nobody is appearing for private respondent.
Manish Kumar appears in.
These are all covered matters, I suppose. Covered matter को भी ready करने के लिए इतना time लगता है.
This is 9th April 25.
11 to 25 is not that order.
9th April 25, let notices be issued to the respondents except the Deputy Commissioner round in the main petition as well as in limitation petition. In all cases.
The learned counsel for the appellant has submitted that on 9th April 2025, the notice was issued to the respondents except the Deputy Commissioner in the limitation matter as well as in the first appeal. He has submitted that the respondents have that the notice has been served upon respondent number
5, 6 and 7.
5 to 7. And respondent number 1 to 4 were reported dead and now they have been substituted. And the name of respondent number 1 has been deleted. Issue notice to the substituted heirs of respondent number 2 to 4. Correct? Through the concerned police station in the IE number 3073 of 2025 as well as in the first appeal. Through the concerned police station. The requisites be filed before this court within 1 week. Within 1 week. Post on 31st. Awaiting service report. It is covered by which judgment?
The batch, portion of the batch has been decided by FA 48 of 2024.
The learned counsel for the appellant has referred to the final judgment passed in FA number 48 of 2024 and other analogous cases and submits that the present case is squarely covered by the same judgment as the present case was also decided analogously with the judgments which were impugned in FA 48 of 2024. And he submits that the records may not be required to be qualified.
Record है.
Record है, चलिए record है, इसको last sentence में बात करें. Next case में क्या?
Item 12.
What is this IE for?
7 to 87 of 24 of 25 was for substitution and deletion.
Okay, who died when?
Respondent number 8 has died issues that has to be deleted. Notices were issued on legal heirs of respondent 1 and 6. 1 has been served by
Respondent number 1, 6 and 8. Yes.
1 has been served by his wife and 6 1 has been served through personally.
And what about 8?
8 died issuance name has to be deleted.
You have filed a petition to that effect. which is ID number
7287.
7287 of 25. ID number 7287 of 25, the learned counsel for the applicant has submitted that. Responding, the petition has been filed for substitution of deceased respond number 1, 6 and 8. He submits that the notices were issued to the proposed legal heirs of respond number 1 and 6 who have been served as per office note, and so far as respond number 8 is concerned, he died issueless. The name is required to be deleted. The notice upon the proposed legal heir of respond number 1 and 6 has been served either personally or through his wife. He submits that the notice be accepted as validly served. Considering the submission, notice upon respond number 1, proposed respond number 1 within bracket 1 and 6 within bracket 1 is accepted as valid. Is there any delay in filing?
Same.
Delay in filing the substitution.
No.
First substitution is to be allowed. Same story.
Same story. Para 5 has stated that they came to know on 15/5/25 when the service report was received.
The learned counsel has submitted that there is a delay in filing the petition for substitution, and they came to know about the death of the associate respondents on 15/4/25 when the service report was received. He submits that delay be unknown, the abatement be set aside, and substitution be allowed. Counsel for the state has no objection so far as the prayer for substitution / deletion of the respondent is concerned. After hearing the learned counsel for the petitioner, appellant and the state, then the notice having been made, the prayer for substitution of respondents 1 and 6 is allowed after condoning the delay and setting aside abatement. So far as respond number 8 is concerned, the respond number 8 having died issueless, the name is required to be deleted. IE number 7287 of 25 is hereby allowed. The counsel for the appellant is directed to carry out necessary corrections in the past writing and ready during the course of the day. How much is the delay in filing the appeal?
264 days.
IE number
1181 of 25.
IE number 1181 of 25. The learned counsel submits that the petition has been filed for completion of delay in filing the first appeal. He submits that notice was issued upon the respondents by the order dated same 9th
0904 9th April
2025, and as per the records, Wakalatnama of respondent number 2 to 5, 7, 9 and 10 has already been filed. इसमें तो दिख रहा है filed है.
Advocate Manish Kumar appears. He has appeared on previous cases.
That's right. However, so far as the legal hearing of respondent number 1 and 6 are concerned, they have not been served notice on the point of limitation. Considering the submissions, let notice be issued to the legal heirs of respondent number 1 and 6 through the concerned police station, for which requisites be filed within a period of 1 week. Was this case on the same date? Who else? What is the next?
The next case has the same party details. The ID numbers are different and the
Same situation?
yes, and the limitation period is different.
Limitation का ID number क्या?
3072 of 25.
So respondent number 1 and 6 had expired, right?
Yes. 1, 6 and 8 have expired. 8 died issues. He has to be deleted. 1 and 6 same service.
6 may, there are 4 substituted years. 6-1 to 6-4. दोनों में 6 का सेम है नाम.
FA 50 of 24.
Yes, FA 50 of 24. As per the office note, there are 4 legal years of respondent 6. दिखाइए ट्रॉफी रिकॉर्ड. Which is IE number?
14891.
उसमें जब देखिए respondent number 6 कौन है? नाम देखिए.
In this case, information was provided by the other council.
Jeetan Ganju.
Yes.
And इसका respondent 6 कौन है?
जीतन गंजी.
उसमें सिर्फ एक ही है क्या प्रपोज लीगल ईयर?
Yes, yes.
एक ही है ना respondent number 6 का
6
देखिए.
है जी. इसमें एक ही है. उसमें 6 1 है.
इसमें तो 4 है.
So, in the FA 50 of 24,
Same person has more than one legal year.
one of the legal heir is the wife and 2 are minor daughters. And I have filed the substitution for substitution of son. This information was provided by the council in this specific case.
Jeetan Ganju is respondent number 6.
Yes.
In the same case also
The
Jeetan.
same
So in one
legal-
case you have only one legal year.
Yes.
And in this case you have so many legal years.
The wife and the minor daughters.
Son भी तो है.
Son has been substituted in both the cases. In one case,
And wife has been left out.
that is, we file the corrected petition.
Addition of party फाइल कर दीजिएगा उसका तालिए हमें लाओ करके. फाइल addition of party. ID number 14891 of 2025. The level council for the appellant submits that this petition has been filed for substitution of respondent number 6. 1, 6 and 8. The respondent number 8 has expired issues, and so far as legal years of respondent number 6 and 1 are concerned, they have been served. The notice has been served upon them or their close family members. Service report is on record. Let the notice, he submits that the notice be accepted as valid. Considering the submissions, a notice upon the respondent number, upon the proposed legal years of respondent number 1 is accepted as valid. While placing the interrogatory application, he submits that the appellant came to know about the death of respondent number 1, 6 and 8 only on 30/7/25 when the service report was received. He also submits that the delay in filing the substitution be condoned and the abatement be set aside and the petition be allowed. Counsel for the state has no objection so far as the prayer for substitution is concerned, considering the submissions of the substitution of respondent number 1 6 is allowed and respondent number 8 having died issueless as stated in the interrogatory application. The counsel for the appellant is permitted to delete the name of respondent number 8. The counsel for the appellant is also directed to carry out the necessary insertions with respect to the legal years and successors of respondent number 1 and 6. ID number 3072 of 25 has been filed seeking confirmation of legal finding recipe. The notice be issued to the legal years and successors of respondent number 1 and 6 through the concerned police station, for which requisites be filed within a period of 1 week. The records reveal that respondent number 25, 7, 9 and 10 have already appeared by filing. और तो कोई बचा नहीं सर्व करने के लिए? Post on the first.
Next.
Record.
There are two.
Yes, what is the situation of the
50, FA 53 of 24.
yes.
IA 14894 was to substitute legal heirs of respondent 1 and 5.
14894.
14894. In this,
Respondent number 1 and
1 and 5.
5.
Two of the legal heirs of respondent 1 resided outside the state. Notices were issued by speed post. The report has come that it shows in transit. The others are shown to were to be delivered by local police station. That has been delivered. So through either personally or through husband.
So they are all close relatives. Whom are you representing?
State.
State.
The two legal heirs residing outside the state are the married daughters.
Notice upon respond number proposed legal years of respond number 1 and 5 were issued. The respond number 1 within bracket 1, 1 within bracket Roman 6, and 1 within bracket Roman 7, 5 within bracket Roman 1 has been received personally, and respond number 1 within bracket Roman 3 and 1 within bracket Roman 5 has been received by their husband. The learned counsel for the applicants understand. The notice upon the opposite respondents be accepted as valid. Counsel for the state has no objection to the prayer made. Accordingly, the notice upon respondent number 1 within bracket 1, 1 within bracket Roman 6, 1 within bracket Roman 7, 5 within bracket 1, 1 within bracket Roman 3 and 1 within bracket Roman 5 are accepted as valid. So far as notice upon respondent number 1 within bracket Roman 2 and 1 within bracket Roman 4 is concerned, the tracking report of the speed post is showing the same in transit.
It should be finally submitted except respondent 1 Roman 2 and 1 Roman 4. Report states that Vakalatnama has been filed on behalf of other respondents.
Yes.
Yes, which comes in the next page after.
Okay. The Vakalatnama on behalf of respondent number 4, 1 within bracket 1, 1 within bracket 3, 1 within bracket 5 to 1 within bracket 7 had already been filed. कौन है वो लोग?
Manish Kumar.
Today is absent.
Yes, otherwise he generally appears.
Since the respondent number 1 within bracket Roman 2 and 1 within bracket Roman 4 appear to be close relative of other legal heirs of respondent, are close relative of other legal heirs of are married daughters.
They are married daughters.
Are married daughters, and the counsel for the other legal heirs of respondent number 1 is absent today. Post this case on next Friday. Well, he will seek instructions. And counsel may seek instructions and if so advised may file wakalatnama on behalf of, if so instructed, may file wakalatnama on behalf of respondent number 1 within bracket 2 and 1 within bracket 4 also. Let a copy of this order be forwarded to Mr. Manish Kumar, advocate who has entered appearance on behalf of the legal case of respondent number 1. Let this, with Tessa,
Yes, yes.
let this case be segregated from the batch and posted on next Friday. If you say takes instructions, it will be easy.
It will be easier.
limitation.
There is also
Yeah, we अभी कुछ नहीं देख सकते हैं अगर उनको instruction मिल जाता है तो easy.
Item 15.
Then there is one more.
IA number
Appearance is there.
14884.
14884 for substitution of
Respondent 2.
respondent number 2.
One legal year has been served through sir.
The IA number 14882. The learned counsel for the applicant submits that the legal year of respondent number 2 has been served. The notice be accepted as valid. Please serve. As during the submissions, the notice upon the legal year of respondent number 2 is accepted as valid. इसके बाद the learned counsel submits that there has been delay in filing the petition for substitution on respondent number 2 as the appellant came to know about his death only when the notice remained unserved
When the service report was received.
and the service report was received by this court and recorded in order dated 37/2025. He submits that the delay be condoned, the abatement, if any, be set aside, and substitution be allowed. The learned counsel for the state has no objection so far as the prayer for substitution is concerned. Considering the submissions and upon going through the interlocutory application, being satisfied with the cause shown, the delay in filing the petition seeking substitution is condoned, the abatement, if any, is set aside, and the prayer for substitution is allowed. The learned counsel for the appellant is directed to carry out necessary correction in the cost title in writing during the course of the day. How much is the delay in filing the appeal?
501 days.
Which is that item?
3067.
RA number 3067 of 2025. Let notice be issued to the substituted legal year of respondent number 2 to the concerned police station for which requisite be filed by the appellant within a period of 1 week. Post this case on 31st. बाकी सब appeal हो गए? Respondent number 1, 3, 4 and 5 have already appeared when filing a correct. Let's see next.
In all the IS for limitation,
31st.
there are
Yes.
supplementary affidavit justifying the cause of death, which is so that has also to be provided by way of notice.
You file it. You file with your supplementary.
Item 16, BA 8156 of 2024.
Rejected matter, rejected.
Epistle.
What I have received, and it has been sent to the bench also,
To the concerned court.
to the concerned court also, and in compliance of last order, affidavit was sworn yesterday just, so it would not require your
You
order.
just give me. Once the epistle comes, we can extend the time by 2 months because that is the fair date that 2 months time is required. B number 8.56 of 24. This matter has been listed. And the bail application was the letter has been received from the concerned court seeking 2 months' time to conclude the seeking extension of 2 months' time for conclusion of trial, and at the same time it has been mentioned that the status of the case is defense argument and awaiting epistle report. The learned counsel for the state has filed supplementary affidavit before this court, which is taken on record, and has submitted that
Reasons for delay. Para 4 onwards.
and has submitted that the epistle report has now been forwarded to the concerned court, and she is in possession of a copy of the same. Yes, she has further submitted that the reason for delay has been explained in paragraph 4 of the supplementary affidavit by stating that the Directorate of Forensic Science Laboratory Ranchi received the exhibits on 30/10/23. The case was initially marked to a reporting officer on 31/10/24. However, the officer was on maternity leave from 21/8/24. Subsequently, the case was remarked on 22/8/24 for DNA examination and preparation of it. And there is shortage of manpower. However, finally, the report has been sent to the concerned. In view of the aforesaid, the time as prayed for by the learned court for conclusion of trial is extended by 2 months from now. Where is the disposal matter? Disposed of.
From the supplementary list, part third matter, 6 at 12:30, item 1, 2nd April 272 of 2009.
The other matters, maybe the bail matters will be taken up in the second half. We are in the midst of this part matter. The bail matters will be taken up in the second half.
Yesterday, I was arguing regarding admission that I have already seen. That is section 17 of Indian Evidence Act. I would like further to refer one more section. Lashima, kindly see section 31.
Yes.
Admissions not conclusive, but may stop. Admissions are not conclusive proof of the matter admitted, but they may operate as a stopper under the
Section 31 of Evidence Act.
Yes.
Evidence Act. देख रहे हैं हमारा सिस्टम कैसा काम कर रहा है. They need to rearrange the books. We have a numbering system. All the books are numbered. So they have a list. लेकिन वो मिलेगा तभी ना जब जगह पे रखेंगे. Like खोज के निकालिए कहाँ. चेम्बर में गया. चेक. पता नहीं लगता चेम्बर में गया.
Section 31, your lordship may grant.
Okay. Right.
Admissions not conclusive, but may stop. Admissions are not conclusive proof of the matters admitted, but they may operate as estoppels other than the provision hereinafter contained. My lord, the first substantial question of law and other additional question of law which are being heard, my lord, together with regard to some admission in the my lord, writ petition. To that only, my lord, I am going to.
Yes.
Then your lordship may kindly see. Section 42. Relevancy and effects of judgment, order or decree other than those mentioned in section 40. Whatever with respect to my lord, probate judgments in probate and etc. jurisdiction. The relevancy and effect of judgment and orders or decree other than those mentioned in section 40. Judgment, orders or decree other than those mentioned in section 41 are relevant if they relate to matters of a public nature, relevant to inquiry, but such judgments, order or decree are not conclusive proof of that which they state. Not here in this particular case. Order of a high court, my lord, in a writ petition is being it has to be taken into consideration. Whether
Not
that,
the pleadings.
my lord,
Not the pleadings.
or pleadings or whatever has been stated, my lord, in the order. And admittedly, my lord, on the basis of pleadings, the order is passed. I agree to that. My lord, yesterday, my lord, my friend, which is already, my lord, part of the exhibit G, has shown that, my lord, except in the first paragraph, my lord has taken note of it. There is no such, my lord, pleading to the effect that we said that they were rank outside. So, my lord, even if, my lord, in the order, my lord, the order of the High Court, in one paragraph, my lord, though there is a submission on the behalf of counsel, my lord, who was appearing at the relevant point of time on behalf of the respondent number 6. But, my lord, those may also be treated as concession and submissions. And my lord, it is a submission of a counsel. Cannot be, my lord, a conclusive proof. So, my lord, so far as, my lord, the law, my lord, contemplates that, my lord, admittedly, admissions are very strong proofs. I do agree with this proposition of law. But, my lord, they are not conclusive. And I am relying on 2 judgments also. I am showing those judgments. Circumstances are to be seen. My lord, my learned senior friend has argued yesterday, and today I will also say that, my lord, writ petition, my lord, the background of the writ petition is, my lord, that, my lord, order of eviction was passed, and pursuant to that, a notice was issued by the subdivisional officer with respect to property, which is a Wasaudi land. And, my lord, I do agree with the proposition, my lord, that, my lord, in such lands, my lord, the subdivisional officer has no power, my lord, to straightway ask for eviction. My lord, in the backdrop of that, my lord, only the Honorable High Court has said that Even an outsider, even if you treat him as an outsider, he has to be evicted as per the law. And thereafter, the liberty was granted to the respondent, and thereafter the suit was instituted. So, my contention is, the facts and circumstances of the order which was passed by the Honorable High Court in said writ petition has to be considered. It should not and ought not to be treated as an admission. That is my perception. Your Lordship, I would like to.
Please hold on. The learned counsel for the respondent has referred to section 31 of the Indian Act to submit that the admissions are not conclusive proof, but they may stop. He has then referred to section 42 of the Evidence Act to submit that relevance and effect of that the judgments, orders or decrees other than those mentioned in section 47 are relevant if they relate to matter of a public nature relevant to the inquiry. But such judgments, orders or decree are not conclusive proof of that which they state. The learned counsel has also submitted that there is no doubt that admission are strong proof or material. Admissions are strong evidence but are not conclusive. He has further submitted that the admission is also required to be seen in the circumstances in which orders are passed. He has submitted that in the Exhibit G, there is no such admission that the
part of the exhibit, IA petition.
In the IA petition, there is no such admission that the appellant hearing were encroachers. And the order passed by the High Court only refers to the submission made by the counsel appearing on behalf of respondent number 6 in the writ petition. He has submitted that the background of the case was that the SDO had directed the present appellant to evict by treating them as encroacher. And ultimately, the court found that no such order could have been passed. And any order of eviction has to be passed in accordance with law and left the remedies open to the parties. The learned counsel submits that firstly, there is no admission in the interlocutory application within bracket Exhibit G, and secondly, there is no such finding in the final order passed by the learned court, which is also a part of Exhibit G. The learned counsel submits that considering the provision of Evidence Act and also on the face of Exhibit G, no such admission could have been inferred by the court. This is over and above the fact that no issue with respect to estoppel was framed in the light of section 31 of the Evidence Act.
I am relying on a judgment passed by Honorable Apex Court, Your Lordship. I kindly submit this judgment. My Lord, may I kindly see para 9.8 and 9.9. 9.9 is the relevant for us. May I read? An admission is not conclusive as to truth of the matters stated there. It is only a piece of evidence, and the weight to be attached to which must depend on the circumstances under which it is made. That's what I was arguing.
The learned counsel has relied upon the judgment passed by the Honorable Supreme Court reported in bracket 1956, bracket close 1 SCC 698, and has referred to paragraph 9.9 to submit that it has been held that an admission is not conclusive as to the truth of the matters stated therein. Rather, it is only a piece of evidence, and the weight is to be attached to which must and the weight to be attached to such admission must depend upon the circumstances under which it is made. It can be shown to be erroneous or untrue, so long as the person to whom it was made has not acted upon it to his detriment, when it might become conclusive by way of estoppel.
The another Malad judgment passed by Honorable Apex Court is Malad 2012 volume 8 SCC Malad 148. Union of India
2012,
versus Ibrahimuddin and us.
148.
140.
The learned counsel has then relied upon the judgment passed by the Honorable Supreme Court reported in bracket 2012 bracket 8 SCC 148. Para number?
Yes. Section 17 and 58.
Para 17.
No, it is on Malad. Just. It is para 27.
Para
27, 32 and 20.
Para 27, 32 and
29.
27, 29.
Admission is a piece of best piece of literature. My Lord, may kindly find para 29.
Yes. The paragraph 27, 29 and 32 to submit that admission is the best piece of substantive evidence that an opposite party can rely upon, though not conclusive, is decisive of the matter unless successfully withdrawn or proved erroneous. Admission may in certain circumstances operate as an estoppel. The question which is needed to be considered is what weight is to be attached to an admission, and for that purpose it is necessary to find out whether it is clear, unambiguous and a relevant piece of evidence, and further it is proved in accordance with the provisions of the evidence.
Yes, that is the reiteration of old.
It has also been held that it would be appropriate that an opportunity is given to the person under cross-examination to tender his explanation and clear the point on the question of admission.
Then, my Lord, so far as the first substantial question of law and the additional substantial question of law related to that is this is my submission.
What about power?
Now, my Lord, so far as the other substantial questions of law is concerned, regarding the power of attorney, which yesterday my learned senior friend has argued, that my Lord, first of all, I would like to show recent judgment that is the law laid down by the Supreme Court. Before that, I would like to show the law. The Lordship may kindly see order 3. Order 3 of the Code of Civil Procedure.
Yes, I did. Yes.
My Lord, may kindly see, my Lord, order 3 appearances, etc., may be in person by recognized agent or by the pleader. Any appearance, application, or act in or to any court required for or authorized by law to be made or to be done by the party in such court may, except where otherwise expressly provided by any law for the time being in force, be made or done by the party in person or his recognized agent or by a pleader appearing, applying, or acting as the case may be on his behalf, provided that such appearance shall, if the court so directs, be made the party in person. Recognized agents. Recognized agents of party by whom such appearance, application, and acts may be made or done are persons holding power of attorney authorizing them to make and do such appearance, applications, and act on behalf of such parties. My lord, the law, my lord, which was interpreted, your lordship, time and again, that, my lord, though he can file, he can, my lord, act, but he cannot depose. Then, my lord, in the recent judgment of, my lord, Honorable Apex Court, that has been clarified, which my learned senior friend has also argued.
He has not denied that he
Yes.
cannot depose. But his contention is that he can depose only to the extent of his knowledge. But if the personal knowledge of the person concerned is involved,
Right.
then he has got no business to depose.
Yes, I am coming to that. Your lordship, just I would like to show the law. My lord, may kindly see para 28. Did my lord find? The law has understood earlier that a general power of attorney, though can appear, plead, or act on behalf of a party he represents, but he cannot become a witness on the part of the party represented by him, as no one can delegate his power to appear in a witness box to another party. However, subsequently in Janki Vasudev Bhajwani versus Indus Bank Limited, 2005, Volume 2, SEC 217, this court held that the power of attorney holder can maintain a plaint on behalf of the person he represents, provided he has personal knowledge of the transaction in question. It was opined that the power of attorney holder of the legal representative should have knowledge about the transaction in question so as to bring on record the truth in relation to the grievances of the offence. However, to resolve the controversy with regard to powers of the general power of attorney holder to depose on behalf of person he represents, this court, upon consideration of all previous relevant decisions, the aspect including that of Janki Vasudev Bhajwani in A.C. Narayanan versus the State of Maharashtra, 2014, Volume 4, SEC 790, concluded that upon upholding the principle of law laid down in Janki Vasudev Bhajwani and clarified that the power of attorney holder can depose and verify on oath before the court, but he must have witnessed the transaction as an agent and must have due knowledge about it. The power of attorney holder who has the knowledge regarding the transactions cannot be examined as a witness. The functions of general power of attorney holder cannot be delegated to any other person without there being a specific clause permitting such delegation in the power of attorney, meaning thereby ordinarily there cannot have any subdelegation. It is therefore settled law that the power of attorney holder can only depose about the facts within his personal knowledge. Here I would like to pause. But if something is in his personal knowledge also, he can depose it.
What is the meaning of personal knowledge?
But
should he be a witness to the entire transaction?
But not necessary. Not necessary. It is suppose that some transaction has taken place. He may not be a witness, but he may have a personal knowledge that such and such transaction has taken place. Law says that what is the requirement in law, that the person must have knowledge, personal knowledge. A person without being a witness in a deed can have knowledge of transactions. And my lord, apart from that, your lordship may kindly appreciate that this is a rent suit, your lordship. This is a rent suit. And my lord, I will show it from their evidence of PW1, who has deposed, that he is aware about the transaction, my lord, that transaction has taken place before him. The transaction by virtue of which we claim the property. So, my lord, so far as the transactions aspects, your lordship,
You see, so far as the transaction of purchase is concerned, it is not in doubt. It has been purchased, there has been a transfer of property
Right.
through registered
Right.
deed. But the knowledge, what is required in a case of landlord-tenant relationship
Right.
is, what was the status of the defendant first party who are that property?
those things have come in the evidence.
So that knowledge is
Yes,
important.
those things have come. And he has been cross-examined also. He has been cross-examined, duly cross-examined. And I'm coming to that, Murat. When a non-examination or a cross-examination not given, Murat, when it can be fatal, I'm coming to that. So far as this person, Murat, who has deposed before on behalf of the plaintiff, Murat, they have already cross-examined, and those parts has been taken into consideration. And apart from that, my lord may kindly appreciate, despite, my lord, the liberty was given to aggrieved party, the my lord, they did not challenge the sale. Till today, there is no challenge. And my lord, not only that.
Sale deed they did not challenge. Why should they challenge? They are in possession. You claim recovery of possession, they will claim adverse possession. Why should they challenge your sale? They are in peaceful possession of the property and you never bothered to evict them. In spite of the fact that you were not, admittedly you are not in possession.
No, I'm not in possession.
Admitted.
That is the reason eviction.
Yes, that is why you file an eviction suit. And had you filed a title suit, they would have claimed adverse possession.
They are claiming today. Today also in this also they
in
have.
This also they have claimed, but there is no identification on that.
Your lordship may kindly appreciate. Two courts of concurrent court, one trial court as well as the appellate court has had that, my lord, his status is a tenant. Your lordship may kindly see section 117 of the evidence. Your lordship, just have a look.
No, let's be here right now on power of attorney. So we are just trying. Your contention is irrespective of the fact as to whether a person has actually witnessed a transaction, he can still have knowledge and depose as a power of attorney.
What I am saying.
Whatever be the source of his
What
knowledge.
I am saying, my lord, even if a person is not a witness, my lord, in the
That's
transaction,
right,
but if he has seen the transaction, or if he say that
He is otherwise aware.
Otherwise aware, he can depose. That what is the law also.
The learned counsel for the respondent plaintiff has, while referring to the first substantial question of law, first additional substantial question of law, वही है ना power of attorney, first additional है ना, the learned counsel for the respondent plaintiff has referred to Order 3, Rule 1 and 2 of CPC and has submitted that the law permits power of attorney to appear, to do such appearance, applications and acts on behalf of the party. And it also provides that if any such appearance is required, the court may direct the party to appear in person. He has then relied upon the judgment passed by the Honorable Supreme Court, reported in bracket 2024, bracket close 6, SCC 130, and has referred to paragraph number 28 and 29 to submit that the power of attorney may depose if he has personal knowledge with regard to the transaction, and personal knowledge may not be derived only through being a witness to the transaction. There may be other sources to gain personal knowledge. And therefore, there was no impediment for power of attorney in the present case to depose before the court. He has further submitted that the cross-examination of power of attorney reveals that his personal knowledge has been tested through cross-examination and he has withstood the rigors of cross-examination on the point of personal knowledge. He submits that these aspects of the matter has been very well considered by the learned courts and there is no perversity. The learned counsel has further submitted that the second substantial question of the first edition substantial question of law is fit to be decided against the applicant. और कौन सा बच्चा?
हाँ बच्चा.
अभी इस पावर ऑफ अटॉर्नी पे मेरा क्वेश्चंस है लेकिन आप पहले अपना कंप्लीट करें.
Then my lord, I would like to
Whether 2 suits or 1 suit club.
Yes, I'm coming. For that, I would like to show. First of all, your lordship may kindly see order 1.
Order 1.
Order.
Yes. Order 1 rule.
Order 1, rule 1. Who may be joined as plaintiffs? All persons may be joined in one suit as plaintiffs, where any right to relief in respect of or arising out of the same act or transaction or series of act or transaction is alleged to exist in such persons, whether jointly, severally, or in alternative. And if such persons brought separate suits, any common question of law or fact will arise. Your lordship, may kindly see the facts of this case, your lordship, that our claim, your lordship, by virtue of the plaintiff number 1 and plaintiff number 2, they claim, my lord, that by virtue of 2 registered sale deeds, they have purchased the property. And my lord, so far as plaintiff number 1, your lordship, is concerned, it was 5 katha and odd. Out of that, my lord, his vendor, my lord, has already, my lord, constructed a house and a well on the remaining portion. And my lord, so far as the property which pertains to, my lord, the second sale deed, your lordship, my lord, there are some orchards, and thereafter, my lord, the vendor himself has, my lord, encircled and boundary, my lord, has put in a boundary.
The entire. What is the total area of the property? Schedule A and B?
5 katha and 14 katha, about 19 katha.
19 katha. So, second sale deed consists of 14 katha.
40 katha.
14, 1 4.
What?
And
first one is 5.
5 katha, which contains the house and the well.
And house and a well. It is in the sale deed, okay. That what I purchased was already constructed.
That's right.
And my lord, and he
because
was.
They were living there.
Yeah, they were living there. And the tenant, which yesterday, my lord, the day before yesterday, I have shown those letters that they asked my vendor to adjust the rent, etc. But on the basis of that, my lord, both the courts have concluded that he is a tenant, the status is a tenant. So, my lord, if your lordship may kindly appreciate, my lord, definitely, my lord, had there been 2 suits, a common question of law and facts would arise, my lord, in such case. So, my lord, and they are not strangers. Your lordship may kindly also appreciate this aspect. That second plaintiff number 2 is the father. Is the father, and after his death, my lord, the other my lord, daughters have also joined. They are also plaintiffs.
And plaintiff number 1 is the son.
No, plaintiff number 1 is the daughter. He purchased, the sale deed was purchased in her name, and the second sale deed was in the name of the father. So after the death of the father, naturally, that everybody has to join. So far as, my lord, the first and second lordship sale deed is concerned, my lord, they, on the basis of that, they, my lord, have the cause of action, and both have the cause of action. Your lordship may kindly see this judgment.
Just a moment. The learned counsel for the respondent plaintiff, by referring to the third additional substantial question of law, has referred to, while answering the third additional substantial question of law, has referred to Order 1, Rule 1 of CPC, and has submitted that the plaintiff number 1, who happens to be the daughter of plaintiff number 2, rightly joined together in the suit as the contesting, as the defendant first party were required to be evicted with respect to the entire property, which was covered by 2 sale deeds, one standing in the name of plaintiff number 1 and another standing in the name of plaintiff number 2. He has further submitted that,
Who happens to be her father?
that's right, Dr. Lee. The learned counsel has further submitted that the purchase deed, the sale deed in favor of plaintiff number 1 reveals that it was for 5 kathas of land where house and a well was constructed, and the sale deed in favor of plaintiff number 2 was with respect to orchard consisting of 19 kathas, and it has come in evidence that the entire 14 kathas, the entire 5 and 14 kathas were surrounded by one boundary wall, and the entire premises, including the house, well, and the orchard, constituted a part of one tenancy. And therefore, the plaintiff number 1 and plaintiff number 2 rightly joined together to find the suit.
But may kindly see the judgment which I have just read. It is 1999, volume 3, SEC 456.
Yes.
Lord, may kindly see, Lord, para 11 onward. Order 1, Rule 3 provides as the law has been quoted. Thereafter, the para 12, Lord, this rule requires all persons to be joined as a defendant in the suit against whom the right to relief exists, provided that such a right is based on the same act or transactions or series of transactions or act or transactions against those the persons, whether jointly, severally, or in the alternative. The additional factor is that if the separate suit would brought against such persons, a common question of law or fact would arise. The purpose of the rule is to avoid a multiplicity of suits. This rule to some extent also deals with the joinder of the cause of action, inasmuch as when the plaintiff frames his suit, he includes person as a defendant against whom he claims to have a cause of action. Joinder of a cause of action has been provided in Rule 2, Order 2, Rule 3, which provides jointness of cause of action, joinder of cause of action. Save as otherwise provided, the plaintiff may unite in the same suit several cause of action against the same defendant or against the same defendant jointly, and plaintiffs have causes of action in which they are jointly interested against the same defendant or the same defendant jointly may unite such cause of action in the same suit. Where cause of actions are united, the jurisdiction of court as regards the suits that depend upon the amount or the value of the aggregate subject matter at the date of instituting the suit. These two provisions, namely Order 1, Rule 3, or 2, Order 2, Rule 3, Order 2.
I read it. The learned counsel has relied upon the judgment passed by the Honorable Supreme Court reported in bracket 1999, bracket close 3, SCC 457, and has referred to paragraph
11 to
10,
14.
para
14 is the concluding.
Para 10 to 14, and has submitted that the Honorable Supreme Court has interpreted the provision of Order 1, Rule 3
And Order 2.
and Order 2, Rule 3,
Yes.
and has ultimately held that these two provisions, if read together, indicate that the question of joinder of parties also involves the joinder of causes of action. The simple principle is that a person is made a party in a suit because there is a cause of action against him, and when causes of action are joined, the parties are also joined.
Just a little correction. Instead of 14, it should be 12. Second.
अच्छा वो 14 जो बोल रहे थे ना 14 कट्ठास
12.
देखिए 5 कट्ठा plaintiff number 1 ने खरीदा है, plaintiff number 2 has bought 12 कट्ठास, so total land is 17 कट्ठास.
Altogether 17 kathas.
Yes.
But almost all substantial questions of law have argued. The last one you'll assume.
Last one क्या है? Last वाला क्या है सबसे?
लास्ट वाला है कि सूट मैटर एक
Oh, whether the root and orchard दोनों का
उससे पहले एक और
नहीं हो गया सब.
नहीं, एक ये बचा है कि क्रॉस एग्जामिनेशन वाला नॉन क्रॉस एग्जामिनेशन वाला पास किया था सब.
वो तो उसी में कवर हो गया.
नहीं वो वाला
Power of attorney.
उसमें हम 2 जजमेंट और थे.
That is relatable to substantial question of law number
2 जजमेंट इसमें हजूर हम दे रहे हैं.
Roman 1, additional Roman 1.
ये 2 जजमेंट हम दे रहे हैं. एक ये जजमेंट है हजूर रतन देवी वर्सेस पसंद देवी. और एक
Para number
इसका पारा नंबर है 5. That the counsel for the respondent has placed reliance on Iswar Bhai Patel versus Hariyar Bahera, wherein this court has emphasized that withholding of plaintiff himself from the witness box, and thereby denying the defendant on an opportunity of cross-examination of himself results in an adverse inference being drawn against the plaintiff. That proposition of law is undoubtable. However, we have already said that it is a fact to be kept in view and taken into consideration by the appellate court while appreciating the oral and documentary evidence available on record. Maybe that from the other evidence, oral and documentary produced by the plaintiff or otherwise brought on record, plaintiff has been able to discharge the onus which may lay on him, and subject to that forming that opinion where an abstention of plaintiff himself from the witness box may fail into an incident. What I want to say, even if an adverse inference is taken, that is to be taken into consideration with respect to the evidence available on it. Whether the other evidences suggest that the onus has been discharged. That has firmly established in this particular.
the learned counsel by
One more judgment I would like to see.
just a minute. With respect to first edition substantial question of law, the learned counsel has relied upon the judgment reported in bracket 2002 bracket close 2nd SCC 441 para 5 and has submitted that even if the plaintiff has not appeared in the witness box, but it could be from other evidence, oral and documentary, produced by the plaintiff or otherwise brought on record, has to be examined as to whether the plaintiff has been able to discharge the onus which lay on him, and subject to the court forming that opinion, a mere abstention of the plaintiff himself from the witness box may not fail into insignificance.
But one another judgment of Honorable High Court, this Honorable Court, in second appeal 15 of 2014, or it was arising out of a tenancy case. In this case, you'll see all the propositions with I am just referring with respect to power of attorney and non-examination of plaintiff has been given.
And
All leading judgments.
the learned counsel has also relied upon the judgment passed by this court in second appeal number 15 of 2014 and has submitted that most of the judgments relevant with regard to examination of power of attorney and non-examination of the
Not cross-examination of plaintiff.
and no opportunity to cross or examine the plaintiff has been taken into consideration. That should be sufficient.
Yes. One last point you'll assume that whether it is a land, whether it is a building or not. Your Lordship, may kindly see section 2 of the Building Act. I'm referring old act. Building means, did my lord find?
Yes.
Section 2B. Building means any building or hut or a part of the building or hut let or to be let separately for residential or non-residential purpose and includes garden, grounds and outhouses, if any apartment, appurtenant to such building or hut or part of such building or hut, and any furniture supplied by the landlord for the use in such building or hut or part of the building or hut. My lord, this definition, my lord, itself, my lord, encompasses. My lord, I have just given the outline. My lord, the building premises, your lordship.
No, that we have seen.
Yes.
You have said so.
Yes, I would like to rely a judgment of this court.
Yes.
The lordship may kindly see, my lord, the judgment passed by this court.
Param.
Yes. Para 4, my lord, 5, 6 and 7. The building has been taken into consideration. Thereafter, my lord, from plain reading from the aforesaid definition, it is clear that the building includes hut or part of the building or hut, and which includes business premises also. Building also denotes a structure to the nature of premises intended for human habitant or the use of non-residential purpose such as business. Even non-residential also. The Supreme Court in the case of Surya Kamar Govindji versus Krishna Mama has considered the definition of building under Tamil Nadu Building Lease and Rent Road. That is with respect to Tamil. But
We are only concerned with the open land
then another
attached
question,
to the building.
that
Otherwise, this judgment is of no consequence.
Then, my lord, in case of Muhammad Shah Alam versus Abdul Hamid, the bench of Patna High Court, while considering the term building, observed there's a definition of what building set out as above in a very wide terms and includes not only garden, grounds, and outhouses.
So it's there in the definition itself.
Yes.
You
Yes.
need this judgment.
So that point of, my lord, substantive question of law, my lord, I have already
The
shown.
learned counsel, by referring to the fourth additional substantial question of law, has relied upon the definition of building as defined under BBC Act to submit that the building includes the garden, ground and outhouses,
Even non-residential.
and even उसका क्या जरूरत है non-residential?
Just to conclude, what conclude I am saying.
It's not required. And therefore, the vacant space around the constructed portion in the present case, which fell within one boundary
Yes.
along with the vacant land,
Yes.
formed a one whole as a part of building, and therefore the plot of land which was adjoining to the building was subject to eviction under the BBC Act along with the building itself.
Yes.
अब आप हमारे सवालों का हो गया आपका? You just tell me that from where do I get that the dependent first party was a tenant for the building as well as the land.
Building as well as?
The land.
Yes. That is in the exhibit itself.
Exhibit कौन सा exhibit?
जो हमने दिखाया था.
Exhibit 3. 3 by A.
7.
Exhibit 7.
3 by A and 7. Yeah.
पढ़ी
इसको देखा जाए 3 और 3/8 3 and 3 इसको हम पढ़ देते हैं, एक बार पहले भी पढ़े थे। आदरणीय सजिदा बाबू, यथोचित आप लोगों का शुभकामना ईश्वर से मनाता हूँ। आगे इस वर्ष मई माह में आए थे, मकान का हालत देखा था, आपको निर्देशानुसार मैंने मरम्मत करा दिया है। क्या आप जब 23/7/82 को दुमका आए थे तो मरम्मत तथा छोड़ने के बाद मकान मिट्टी के खर्च का हिसाब दिया था, जिसको आपने देखा था। फिर भी खर्च का ब्यौरा मैं लिख कर आपके पास आवश्यक कराई दिनांक 8/2/79 को हिसाब आपको रजिस्ट्री द्वारा भेजा था, जिसके अनुसार 31 दिसंबर 78 का भाड़ा एवं बागान के फल का सालाना कीमत
आगे पढ़ी
काट कर मेरा पावना आपके पास 1545 रुपया 94 पैसे रह गया था, जिसे जनवरी 1971 से 21 अगस्त तक दिहाड़ी तक कुल 44 महीने का मकान भाड़ा 30 रुपया प्रति माह की दर से 1330 तथा 1971 से 81 तक का बगान के फल में कीमत 75 के दर से 255 रुपया सच वसूल हो जाता है तथा मेरा अग्रिम 94 रुपया रहता। उसके बाद खर्चा का हिसाब दिया, जुलाई का फल तोड़ाई, ताड़ फड़ाई और ये सब टमटम लकड़ी चिराई कुली ताड़ फड़ाई सब दिए हैं। उसका लास्ट पैराग्राफ हम पढ़ते हैं। इस तरह मकान मरम्मत में कुछ कुल खर्च तथा पिछला बाकी मिलाकर 2039 रुपये 64 पैसे मात्र हुआ, जो आपके पास मेरा पावना था। उपरोक्त रकम से आप 1 दिसंबर 83 से 31 मार्च 87 तक कुछ 55 महीना का मकान 30 रुपये प्रति माह के दर 1650 रुपया तथा बगान के फल का कीमत 1986 से कुल इतना तक का प्रति वर्ष की दर से इतना रुपया होता है। इस तरह पावना से आप 13 मार्च तक का मकान का भाड़ा बगान के फल का कीमत को मिलाकर इतना होता है। मेरा पावना रह गया 31 मार्च 2027। इनका तो खुद लेटर से हजूरी खुद कह रहे हैं कि टेनेंसी है और हमको एडजस्ट कर दीजिए, फल का भी है, इसका सब कुछ है। और ये दोनों डॉक्यूमेंट को कोर्ट ने, ये तो एग्जिबिट 3 हुआ, साथ भी देखा जाए। आदरणीय सचिता बाबू, यथोचित आप लोगों का शुभकामना परम पिता परमात्मा से मनाता हूँ। आगे छोटन बाबू 31/12/78 को दुमका आए थे, मैं बाजार की ओर गया था, वो वापस देवघर चले गए, जिससे मुलाकात नहीं हो सकी। मैं उनसे मुलाकात करने के लिए देवघर 11 जनवरी 79 को गया था, लेकिन मैं मालूम हुआ कि भागा कार्यभार ग्रहण करने के लिए चले गए। मुखिया जी से मालूम हुआ कि छोटन बाबू कह रहे थे कि मकान का हिसाब नहीं मिला है। जहाँ तक कि मकान मरम्मत के खर्च का प्रश्न है, वह तो मैं 10 लाख आपको दे आया। उसके बाद भी मकान में हर साल कुछ न कुछ मरम्मत का काम कराना ही पड़ता है। अगले साल भी जनवरी या फरवरी में छोटन बाबू दुमका आए थे, उन्होंने मकान आकर देखा था, जहाँ मरम्मत का तत्काल आवश्यकता थी उसे दिखा दिया था। उसके निर्देशानुसार ताड़ का रोला लेकर जहाँ जहाँ आवश्यक था करा दिया है। पुराना और कच्चा मकान होने के कारण ये मरम्मत के बाद पर खड़ा हो गया है।
ठीक है, these are the documents we are relying upon that. आपका PW1 process.
Yes. PW1 is the purpose. क्रॉस एग्जामिनेशन पढ़ने का। मुंगेर में हुआ, मेरा अस्थायी मकान मुंगेर में है, मेरे कपड़ा का व्यवसाय है। दुमका 96 में आया, यहाँ कपड़े का व्यवसाय फुटपाथ पर करता हूँ। कभी कभार घाट में भी फुटपाथ पर दुकान लगाता हूँ। घाट के अंदर नहीं बेचता हूँ, रोड पर बेचता हूँ। फुटपाथ पर बेचने का कोई लाइसेंस नहीं है। फूल साहिबान एवं लक्ष्मी मियाँ बौद्धिक लिंकेज से मेरी कोई रिश्तेदारी नहीं है। ये लोग बेतिया के रहने वाले हैं, उनके कारोबार से मेरा कोई सरोकार नहीं। पावर ऑफ अटॉर्नी पर मेरा फोटो नहीं है। पावर ऑफ अटॉर्नी रजिस्टर्ड है, रजिस्ट्री ऑफिस से रजिस्टर्ड नहीं है, नोटरी के यहाँ से रजिस्टर्ड है। पावर ऑफ अटॉर्नी पर नोटरी साहब के सीरियल नंबर लिखा है। नोटरी साहब ने पावर ऑफ अटॉर्नी पर ऐसा सर्टिफिकेट नहीं दिया है कि फुल साहिबीन एवं लक्ष्मी मियाँ में उनके समझ का यह रजिस्टर किया है। इस पर शपथ पत्र का सर्टिफिकेट है। यह बात मुझे समझ में नहीं आ रहा है। यह बात सही नहीं है कि शपथ पत्र के प्रथम पृष्ठ को बदलकर मैंने पावर ऑफ अटॉर्नी बनाकर फोर्जरी किया। मैं थोड़ा अंग्रेजी पढ़ना जानता हूँ, स्पेशल पावर ऑफ अटॉर्नी का मतलब समझता हूँ। यह मुख्तार है, मुख्तारनामा का मतलब नहीं समझता। समय अभाव के कारण जीरा अगली तारीख। इस पावर ऑफ अटॉर्नी पर मेरा था फुलसाबिन का कोई फोटो नहीं है। बादीगर ने यह जमीन मालिकाना हेतु दाखिल किया है। मैं बगैर देखे सभी प्रतिवादियों का नाम नहीं बता सकता। अर्जी में लिखी बातों की मुझे व्यक्तिगत जानकारी है। होश के आने से पहले की बात जो लिखी गई है वह सबकी जानकारी सजुदा बाबू के बताने एवं पढ़ने से कौन कौन दस्तावेज दाखिल है यह देख कर बता सकता हूँ, बगैर देखे नहीं बता सकता। रजिस्ट्री विक्रनामा फूल साहिबा एवं लक्ष्मी को हुआ और म्यूटेशन कागज।
आप जरा इसमें आइए, इंटरनल पेज 14 सन 1972 से।
हाँ, सन 1972 से विपिन बिहारी रहते थे। इसके पहले सचिता बाबू एवं छोटन बाबू रहते थे। मैं रहते नहीं देखा था। सचिता बाबू सन 72 में भाड़ा देकर मेरे सामने नहीं दिए थे। भाड़ा 30 रुपया महीना पर दिए।
मकान 30 रुपए महीना पर दिए थे।
सचिता बाबू 72 में भाड़ा पर मेरे सामने नहीं दिए थे।
हाँ, नहीं दिए थे। मकान 30 रुपए महीना पर दिए थे। इसको थोड़ा धीरे से पढ़िए।
मकान 30 रुपया महीना पर दिए थे। मकान 3 कट्ठा में था। समूचा बगीचा 75 रुपया सालाना पर दिए थे। बगीचा में मकान नहीं।
ये दोनों अलग अलग टेनेंसी बना रहे हैं। अलग अलग टेनेंसी बना रहे हैं।
नहीं तो एक ही बाउंड्री में था।
अलग अलग टेनेंसी बना रहे हैं। मकान का टेनेंसी बना रहे हैं 30 रुपए महीना, बगीचा का टेनेंसी बना रहे हैं 75 रुपए महीना। और आपके सूट में आपने क्या लिख दिया है कि 30 रुपए महीना के हिसाब से हम भाड़ा देंगे।
दोनों हम हमारा प्लान देखिए।
ये चीजें 75 रुपए भाड़ा का काम ही है क्या?
है 75 का भी कहानी है।
दिखाइए
दोनों का, बल्कि एरिया से मांग रहे। और 7 देखा जाए। पारा 7 मकान का है। पारा 8 में देखा जाए। Since 1972, however, the said we have Pandey began to pay monthly rent of 30. It is not out of mention that the said Vikram Bihari used to pay sum of ₹75 as per the account of price of fruits of the trees standing on the land side.
It is price of fruits.
Fruit मैंने फल।
बगीचा है। ये समूचा बगीचा 75 रुपए सालाना पर दिए।
हाँ तो कहाँ क्या?
वही एविडेंस। देखिए, प्राइस ऑफ फ्रूट इज डिफरेंट फ्रॉम रेंट ऑफ द प्रॉपर्टी। इट्स नॉट वन एंड द सेम। वही आपका एविडेंस। इसी मकान का भाड़ा 30
हाँ, तो
रुपए।
इसमें तो पर एरिया लिखा हुआ
शेड्यूल
है।
ए में 1 कट्ठा में मकान बना है, इसी मकान का भाड़ा
नहीं
30
तो इसमें
रुपए
प्लेंट
है।
में भी 75 रुपया पर ईयर लिखा हुआ
75 रुपए पर ईयर भाड़ा नहीं लिखे हैं आप? क्या लिखे हैं?
है। सम लिखे इसमें लिखे हैं जो नॉट आउट ऑफ प्लेस टू मेंशन दैट द सेड विपिन बिहारी पांडे used to pay a sum of rupees 75 per year on account of price of fruits of the said tree.
यस, दोनों फर्क है ना। यहाँ पे लिख रहे हैं कि 75 रुपए भाड़ा है, वहां बोलते हैं प्राइस ऑफ फ्रूट।
75
You see
रुपया
the tenancy is,
75
आप
रुपया
इसको इस
सालाना
पूरा
पे।
एविडेंस का ठीक से पढ़िए। Tenancy is only in connection with the building.
हाँ लेकिन
You see, he also says that कुआं एवं फल का पेड़ है, शेड्यूल बी कुआं एवं बगीचा है, जिससे एक सेकंड, शेड्यूल ए में 1 कट्ठा में मकान बना है, इसी मकान का भाड़ा 30 रुपए है।
हाँ मेन भाड़ा 30 का है इसका
आप डिफॉल्टर में क्या बोले हैं? आपने एरियर्स ऑफ रेंट क्या प्ली किया है? 30 रुपीज।
30 रुपया
ये 75 रुपए का क्या?
75 रुपया इसका है।
देखिए मिस्टर शर्मा, व्हाट इज एग्जैक्टली हैपन? जमीन है, साथ में वो है। जमीन का तो बीबीसी होता नहीं,
हाँ।
तो दोनों ने मिलकर जमीन और मकान मिला दिया और बीबीसी एक्ट केस कर दिया। यही तो किया है। आप देखिए आपके प्लेन में शेड्यूल में क्या है? शेड्यूल सी इज व्हाट? 75 रुपीज इज इंक्लूडेड, नॉट इंक्लूडेड।
Areas of rent
एरियस ऑफ रेंट में 75 रुपीज है,
30
रुपीज है। और आपने अपनी चिट्ठी में क्या लिखा है कि प्राइस ऑफ फ्रूट्स इज बीइंग एडजस्टेड अगेंस्ट रेंट।
बहुत 30 भी है 75 भी
इससे कैसे निकलिएगा
नहीं
सर?
75 रुपया
इसीलिए ना, वो जो so far as this tenancy of this land is concerned,
हाँ।
इसके लिए बहुत जरूर, ये जो क्रॉस एग्जामिनेशन में बोल रहा है कि 75 रुपए लैंड का रेट है,
एनुअल
एनुअल है चाहे कुछ भी है,
नहीं, annual
75
rent।
रुपए लैंड का रेंट है।
एनुअल
He is
रेंट
not
इसको
saying-
रेंट कहा जाए या इसको माने जो भी उनके लीव ऑफ में जो भी कहा
ये क्या
75
सुनिए?
रुपया साल में फ्रूट का देना है। मैं तो 30
नहीं,
रुपया
ऐसा एविडेंस नहीं है ना।
ऐसा है एविडेंस भी वही
आप
है।
पढ़िए,
आप पढ़ रहे हैं।
पढ़िए,
पहले हम यहाँ से पढ़ लेते हैं नहीं पढ़
पढ़िए।
हम पढ़ पहले हम इसको पढ़ देते हैं जो पढ़ रहे हैं।
हाँ,
पारा 8 देखा था
पैरा 8 ऑफ द प्लेन।
पारा 8 ऑफ द प्लेट
पढ़िए।
We have that since the year 1972, however, the said Bihari Pandey began to pay a monthly rent of 30 only after expiry of every month. It is not out of place to mention that the said Bihari Pandey used to pay a sum of rupees 75 per year on account of price of fruits of the said trees standing on the said land as described in the Schedule B of the plant after selling the said fruits as per the agreement arrived between the defendant second party and the between Bihari Pandey. हमारा इसमें 30 रुपया महीना पर ही ये हमको इनको दिया गया था और जहां तक कि बगीचा लगा हुआ है उसका सिर्फ 75 रुपया साल का है। तो उसमें जो अगर देते होंगे उसको एडजस्ट करने का बाद उसको भी साथ में लिखे हैं एग्जिबिट 3 और 7। और ऐसा कानून में कोई बार भी नहीं है कि अगर मान लीजिए जैसे 30 रुपया महीना पर अगर हम मकान दिए हैं तो अगर कोई ऑर्चर्ड उसमें है तो उसका पैसा हम नहीं दे सकते। ऐसा तो कोई बात नहीं। अब हम बिल्डिंग का डेफिनेशन में दिखाए कि ऑर्चर्ड।
और आप देखिए, आप शेड्यूल सी एंड शेड्यूल डी में यूज ऑन अकाउंट ऑफ प्राइस ऑफ फ्रूट्स। शेड्यूल सी इज फॉर रेंट, एरियर्स ऑफ रेंट,
हाँ,
एंड शेड्यूल डी इज फॉर द प्राइस ऑफ फ्रूट।
हाँ इसका है, लेकिन ये ईयर का है as per the year 75 per year.
But here it's okay. But it is for the price of the fruits.
Price of the fruits. I agree to. इसमें इसका 75 रुपया प्राइस अगर मान लीजिए साल में अगर हमारा इतना अगर बगीचा है तो हमको क्या 75 रुपया भी नहीं मिलेगा। इतना फल अगर है तो
बगीचा टेनेंट को देती है, फल वही
तो हम तो मकान दिए हैं, टेनेंट तो साथ में ले रहे हैं।
यही तो वो बोल रहे हैं कि मकान के साथ ही जमीन और ये ट्रीज एंड फ्रूट्स,
ये पूरा बाउंड्री में जो मकान है उसके साथ जो बगीचा है तो बगीचा का भी 75 साल में बोल रहे हैं, मंथली नहीं।
कब का है?
उतना फल है।
77 का सूट है सर।
नहीं ठीक है।
हाँ, तो 77 में तो 75
तो
का बहुत
उतना फर्क है, 75 रुपया ज्यादा नहीं।
उतना कितना पता
बहुत
कितना
ज्यादा।
who knows?
आई नो।
अच्छा ये खाली एक ये जो एविडेंस आप पढ़ रहे थे इसको कंप्लीट कर
हाँ,
दीजिए,
हाँ,
उसके
ठीक।
बाद अपना कंक्लूड करिए, then we'll see what else.
उसमें कंसिस्टेंसी है, इसमें
हाँ,
कोई
पढ़िए पढ़िए
72 में विपिन बिहारी रहते थे, उससे पहले सचिता बाबू एवं छोटन बाबू रहते थे, पहले नहीं देखा था। सचिता बाबू 72 में भाड़ा पर रहते थे, मेरे सामने नहीं दिए थे।
सन 72 में भाड़ा पर मेरे सामने नहीं दिए। ठीक है, आगे।
मकान 30 रुपया महीना पर दिए।
हाँ।
मकान 3 कट्ठा में था, समूचा बगीचा 75 रुपया सालाना पर दिए थे। बगीचा में मकान नहीं, कुआं एवं फल का पेड़ का फल है। शेड्यूल बी कुआं एवं बगीचा है जिसे लक्ष्मी मियाँ खरीदा है। शेड्यूल ए में 1 कट्ठा मकान बना है, इसी का मकान का भाड़ा 30 रुपया। कितना कोठरी और कितना बरामदा मैं नहीं बता सकता। इस मकान का 2000 में हो गया था। गेट के बाद थोड़ा पत्ती जमीन है जिसमें फूल पत्ती लगा है, इसमें फलदार पेड़ नहीं है। नारियल का पेड़ इस पत्ती जमीन पर नहीं है। पीछे में कितना जमीन का बगान है नहीं बता सकता। बात सही है कि सरकारी मकान एवं बगीचा का मुझे व्यक्तिगत जानकारी नहीं है। मैं नहीं बता सकता कि भाड़ेदार को कानून भाड़े की रसीद देना जरूरी है कि नहीं। सचिता बाबू और छोटन बाबू को भाड़ा वसूल करते मैंने नहीं देखा था। भाड़ा का रसीद नहीं देखा था। सचिता बाबू एवं छोटन बाबू को सन 2000 में रजिस्ट्री करते समय देखा था।
आप उनको इतना बताइए, asking for rent, is it the same thing asking for the price of fruits? Yes or no?
Lord, so far as
देखिए एडवोकेट की तरफ, लिटिगेंट की तरफ मत।
हम पता है एडवोकेट की तरह आस्किंग फॉर रेंट जो है
Ask the rent would be payable irrespective of anything.
Yeah.
वो बंजर हो जाए जमीन, चाहे सब पेड़ मर जाए, not concerned.
ठीक।
In your suit, you say that was the amount payable for the price of the fruits.
Price main is the rent. Price of fruit is as because those are there, those orchards are there.
Yes, they
But
are there.
that and if the
But it is not a component of rent. Does it form a part of rent?
it is a component.
Component of rent?
No, it may not be in the sense because tenancy is with a monthly tenancy. So 30 rupees per month.
So therefore, 30 rupees per month is clearly severable from 75 rupees per year.
Yearly.
दोनों अलग है ना बिल्कुल।
लेकिन जो 30 रुपीज का जो रेंट है तो मकान के लिए
वो ठीक है ना, वही तो वो बोल रहे हैं। तो मकान के साथ जमीन कैसे जुड़ गया?
नहीं तो मकान के साथ जमीन इसलिए जुड़ा है कि दोनों साथ में है।
अरे भाई साथ में रहने से क्या होगा?
नहीं साथ में रहने
टेनेंसी तो मकान का सिर्फ 30 रुपए पर मंथ,
नहीं ठीक,
और मकान से पोर्शन ऑफ प्रॉपर्टी पर है, right?
हम इसको
Is there any tenancy created? If the tenancy is created for the land and the building together, then either the tenancy would be monthly or yearly or whatever. It will be a composite tenancy for the entire building consisting of the land also. But there is a separate tenancy with respect to land, which is on the basic tenancy at best, which is on yearly payable on yearly basis. And so far as the property, that building is concerned, you specifically state that it was only for the building consisting of how many katthas building and the land whatever, the well, and it was only for 30 rupees.
Yes, I agree to that. That is the tenancy, 30 rupees per month is the tenancy.
ठीक है, अब तो इसको हम सोचेंगे।
नहीं ठीक।
हाँ ठीक है, अब एक चीज और सोचना है।
हम एक let me allow me to answer. अगर ये टेनेंसी अगर 30 रुपीज का है, 30 रुपीज का टेनेंसी, और इसके साथ अगर कोई अगर चीज मान लीजिए अगर फ्रूट का भी एग्रीड है, कोई फल का दाम साल में है, तो प्राइम कंपोनेंट इसका टेनेंसी इज विथ रिस्पेक्ट टू दी।
ऐसा नहीं बोल रहे हैं,
ऐसा
टेनेंसी नहीं, जस्ट अ मोमेंट। मकान 30 रुपए, जस्ट अ मोमेंट, मकान 30 रुपए महीने पे दिए थे। मकान 3 कट्ठा में था।
हाँ
3 कट्ठा ओनली। मकान 3 कट्ठा में था।
बाद में 1 कट्ठा बोल।
नहीं ठीक है, मकान 3 कट्ठा में था। समूचा बगीचा 75 रुपए सालाना पर दिए थे।
हाँ तो हम वही हम कह रहे हैं हुजूर कि अगर मान लीजिए अगर दोनों अगर पोर्शन एक साथ क्लब पूरा बाउंड्री के अंदर, तो इनको अगर हम अगर मकान अगर इनको इनका वेंडर इनको दिया था जो हम परचेज आई एम परचेज, उसमें अगर ये दोनों इनको दिया गया था तो हमको तो वही मिल रहा है।
बहुत दिमाग लगा के प्लेन बनाया गया है, इतना तो हम बोल
नहीं
सकते
ऐसा
हैं। क्यों दिमाग लगाना क्या
अच्छा,
कोई डेरोगेटरी वर्ड है?
इसमें
दिमाग लगाना डेरोगेटरी वर्ड नहीं है। दिमाग लगाना मतलब ड्यू एप्लीकेशन ऑफ माइंड की बीबीसी एक्ट में कैसे आएगा?
नहीं बीबीसी एक्ट में आएगा, इसलिए आएगा
अच्छा,
कि
ठीक है।
अगर इसलिए आएगा इसलिए
अच्छा एक चीज और बता दीजिए, वो
इसलिए-
तो हम लोग देख लिए। बीबीसी आई लुक इनटू इट। ऐसा नहीं है कि आई क्लोज माय माइंड।
let me answer.
One thing more. Is this मकान का भाड़ा
हाँ,
and the land
yes.
severable?
मकान का भाड़ा वाला है।
अगर मान लीजिए this court ultimately finds that what was given in tenancy in the building was only 3 katthas of whatever katthas of land and the building standing thereon at the rate of ₹30 per month, right? And this court holds that the land will not come under the BBC Act. Assuming for a moment, still the eviction on the building would sustain or not?
My lord, so far as this particular case your lordship is concerned, my lord, may kindly take into consideration that I am a purchaser from my vendor, and my lord, there was already a tenancy. Your lordship may kindly appreciate there was already a tenancy, and my lord, that has been established by 2 concurrent courts. And my lord, the tenancy, your lordship, they have asked for certain adjustments also. So my lord, what I purchase from my vendor, I am entitled for that one. And my lord, by
You see, you are entitled for that whatever you have purchased. If there is a default in payment with respect to land, if there is a default in payment with respect to rent or whatever with respect to land, you have a remedy else, not under bills.
my lord,
That is the
to that I am only answering. Your lordship may kindly appreciate. Had I purchased the property, and thereafter, my lord, I would have let it like that. Then the situation is something different. It is what I, my lord, what I am asking for the eviction. And my lord, so far as the land building, my lord, definition I have already shown. My lord, in the building premises, my lord, that is totally boundary, my lord, having under the same boundary, your lordship may kindly appreciate. And if, my lord, there is a house and there is a land and there is a orchard, my lord, and my lord, there is no bar. There is no bar. That's what the law I have just said, my lord, section 2B.
Anyways, concluded for your part?
Yes.
आपको कुछ बोलना है?
First of all, the argument that he is making that these are two component, one component, that's against his plant itself. Because the scheduled properties are two different, purchased by two different sell deeds. One is the agricultural land, the other. And just now, in the deposition, it has said that मकान बगीचे में मकान नहीं है. So it doesn't consist of any building. I have said yesterday that had there been a building along with the herd, with the orchard, that would have come within the definition of building, but not the land alone. Secondly, he has taken your lordships to the pleading and admission. Now kindly see, order 8.
So we
Of
have
the
some
CPC.
human rights also.
हाँ?
2:15 बजे आते, 15 मिनट में हो जाएगा ना complete?
हम तो कंक्लूड करके हमको बाहर निकलना है, इसीलिए हम एग्री किया कि 12:30 बजे
अच्छा,
कर
ठीक
लें. Just I don't take more than 2-3 minutes. He has taken your lordship to the pleading, to the admission, but not denial. That is explained in order 8, rule. Kindness. What should be the denial?
Order 8 rule.
Rule 5. If there is no specific denial, your lordship will put it out, and then you will understand. If there is no specific denial of a document, then it amounts to admission. And once it amounts in an admission, that under section 58 of the Evidence Act, there is nothing required to be proved. I am saying this
Under
in the
section
background.
58.
58 of the Evidence Act. I am saying this in the background of the fact with regard to the substantial question of law 1, 2 and round 3 of the additional. Because the writ was filed by me saying that this SDO is trying to forcibly evict me on the ground that I am an illegal encroacher. The High Court issued notice then. Now you are about to reply. In your reply, you have not denied these facts. On the contrary, you say that it was a abundant holding. You have never pleaded that he is my tenant, not an illegal encroacher. That amounts to admission. And if for that, kindly take down one judgment. 2007, volume 7, volume 6. 2007, volume 6, XCC, 401, paragraph 12 and 13. Thus, if a plea which was relevant for the purpose of maintaining a suit had not been especially traversed, the court was entitled to draw an inference that the same had been admitted. A fact admitted in terms of section 58 of the evidence need not be proved. That's the law. That's the doctrine of non-practice. I am only to that, and I have replied that. Nothing else. Whatever judgment he has relied upon, my lord, is in the different facts. And earlier also, yesterday also, he has relied on the pleading in the writ petition and civil. That's it. It's a law. In fact, that judgment, if you read paragraph 20 of that, it favors my contention. Exactly what the law that I have is not. That's all.
The learned counsel for the respondent by referring to the fourth substantial question of law has submitted and has further submitted that as per the plaint itself, the rent was fixed at the rate of ₹30 per month for the building, and further an amount of ₹75 per month was payable for the fruits on the vacant land pertaining to the building. He submits that the rent on the vacant land, the amount payable for the fruits on the vacant land and the rent of the building constituted a one whole, and therefore the suit was maintainable. The evidence, the cross-examination of the
PW1.
PW1 has also been placed, and particularly paragraph number 34 of the cross-examination. And has been extensively read by both the parties. That's all. The learned counsel for the appellant has referred to Order 8, Rule 5 of CPC and has submitted that if a document is not denied, it amounts to admission. He has then referred to Section 58 of the Evidence Act to submit and has further relied upon the judgment passed by the Honorable Supreme Court reported in bracket 2007 bracket close 6 SCC 401 paragraph 12 and 13 to submit that a fact not traversed by a statement in the written statement amounts to admission.
This is with respect to G, Exhibit G.
This submission has been made with respect to Exhibit G. That's all. Conclusion. ये जो भी आपका डिक्टेशन है आज का कल का, it will be uploaded and then ये तो डिक्टेशन हम अपलोड करते हैं for your memory and for my memory. इसीलिए साथ साथ लिखाते हैं. हाँ सर.